Greetings everyone from lovely northeastern Ohio. I am Aretta Bernard and I'm a shareholder with USLAW member network firm Roetzel and Andress. It's a great pleasure to have a few moments to speak to you today about Ohio's unique anti-discrimination statutory framework. First, not so fun unique fact, Ohio's anti-discrimination statute currently has a 6-year, you heard me right, 6-year statute of limitations. You can only imagine how difficult it is to manage cases that are filed on the eve of the statute of limitations running, including trying to find retired witnesses or witnesses that were long ago terminated, in addition to witnesses that are now deceased, as well as documentary evidence that has long been put in storage or lost. So in addition to that first long statute of limitations, the second not so fun fact about Ohio's statutory framework is that our discrimination statute does not require an exhaustion of remedies. So there's no investigation done by the Ohio Civil Rights Commission, no right to sue letter. You can go straight to court in Ohio up to 6 years after the alleged discriminatory act. And final third and not so fun fact is that unlike Title VII, there is individual liability under Ohio's statutory framework, as employer is defined as anyone acting directly or indirectly in behalf of the employer. That applies to everyone except public sector employees. So what is the Ohio legislature doing about these unique anomalies in our statutory framework? Currently pending is Ohio House Bill 352. The key aspects of Ohio House Bill 352 would change the definition of employer to delete as a definition, the person acting in behalf of the employer. It clarifies that no individual liability would lie against a supervisor, manager, or other employee unless that employee is indeed the employer, or there's a claim of retaliation, aiding and abetting, or obstruction of applying Ohio's civil rights statute, which would all lie against an individual. In addition, the new statute would require an exhaustion of administrative remedies similar to Title VII and what we're used to in dealing with Title VII. So you would be able to file there, you could request a right to sue letter after 60 days have lapsed. So finally, the new statute would limit the statute of limitations currently from 6 years to 2 years, which would be a huge improvement from where we are. This bill is still pending for now, so we're hopeful that these changes will soon be coming. So now that I've told you about the not so fun facts about our statutory frameworks, I want to tell you something about a fun fact about Ohio, and that is, if you happen to visit, please take a look at the Rock and Roll Hall of Fame. Everybody knows about that. But then take a drive to Port Clinton and jump on the Jet Express and go visit the best kept secret in Ohio, Ohio's beautiful islands, including South Bass Island, home of Put-in-Bay, Ohio, which is our little Key West up north. I hope you all stay safe, healthy, and well.